This courtroom hearing quickly turns into a tense and unforgettable showdown. Triarius Trevant Bryan appears before the judge facing charges for allegedly stealing a car, but from the very beginning, it's clear this won't be a simple sentencing. In what seems like an attempt to gain sympathy, Bryan brings his child into the courtroom. Whether it was planned or impulsive, the move doesn't have the effect he hoped for. The judge immediately addresses it, stating she's seen this kind of tactic before and ordering that someone come pick up the child. Just like that, any attempt at emotional leverage is shut down. As the hearing continues, the judge reviews Bryan's background, and it's not in his favor. His record includes prior retail fraud convictions, motor vehicle-related offenses, and multiple outstanding warrants. The tension builds as the court questions his credibility, especially when he claims to be employed despite earlier reports suggesting he had been unemployed for months. Then comes the sentence, 40 days in jail, along with fines and court costs. Instead of accepting the ruling calmly, Bryan reacts with frustration, letting an expletive slip out. The judge instantly warns him that she can add another 30 days for contempt if he continues. For a brief moment, it feels like he's seconds away from making a bad situation even worse. Although the judge ultimately decides not to impose the extra time, the warning is clear. What started as a straightforward hearing turns into a powerful reminder that in court, every word and every action can have serious consequences.
As far as his employment status, he, since January of 2024, has been working at Cosmic Comics, both in Livonia and Fraser. Both locations earn $340 a week. He'll lose that job if he has to go to jail. He has been living in Romulus with his girlfriend. They've been together since 2019. They have 2 children together, ages 1 and 7 months. He just made arrangements for her to pick up the 7-month-old. He's not been incarcerated in several years. He does have a pending matter in Wayne County that's set for sentencing next Monday.
Mr. Mohammed, your name?
Good morning, Your Honor. Mohammed on behalf of the people.
You wrote down full restitution on this. I just want you to be aware, this is the B&E vehicle to steal property, 200 or more. I just want you to be aware that none of the victims are here. The less than 200, I'm sorry. He pled the count 2 was dismissed. But Lisa, just confirm that my understanding is correct. It looks like he pled guilty to count 1, which is the 1 year, and count 2 was dismissed. Is that true?
That's correct.
So I just want you to be aware of that.
And Judge, I apologize. Which case is this?
This is Triarius Trevant Bryan. It's a B&E vehicle to steal property, 200 or more, but less than 1,000. It's a 1 year. So I just want you to be aware. I called the names. You're not here. You just put down PSI full restitution, and none of them show. So I'm not going to order any restitution out.
And Judge, may I ask, does the court send notices to them, or?
Yeah, we did send those.
Okay.
The probation department did when I ordered the pre-sentence report.
So,
Okay.
I understand, Judge. Thank you.
All right. Anything else, Mr. Carmen?
Yeah, just as my client shares, the care and custody of 2 young children, his girlfriend that he lives with. If he's got to go to jail, it's going to be very hard.
Think about these things before we go out and steal. I mean, seriously. I don't know if you do or not. I find it a little hard to believe. I mean, you could sit and give me lip service, but you had a RNC motor vehicle in 2021. You had a domestic where you didn't comply with probation in 22. Conviction was entered on that. You had a retail fraud in 23. We're just convicted of felony retail theft in Illinois. We have another case, you're bound over to the 33rd, I'm sorry, bound over from here, stealing or retaining without consent a financial transaction device. If that's the case, he's going to be sentenced on?
Yes, Your Honor, and there's a sentencing agreement in that case of 2 years probation.
I mean, that's great.
But I'm just informing the court.
No, I get it. I'm just telling you, he's got it, bench warrants out of the 34th for assault and battery. Bench warrant out of the 52nd for retail fraud 3. The bench warrant for retail fraud 3 out of Southgate. Retail fraud bench warrant out of the 16th. You up on any of those?
Yes, Your Honor.
When?
I've been taking care of the warrants since I've been out, Your Honor, and
Lisa, can you run his lien again for me, please? This lien is a few days old. Let me just double check.
And my client indicated he's contacted those courts.
You contact.
yes, Your
What do
Honor.
you mean?
I contacted those courts and they told me that I have to turn myself in and schedule it.
Well, you haven't taken care of the warrants then, have you?
No, I have been taking care of some of the warrants, Your Honor.
I'm sorry?
I have been taking care of them.
All right, I'm gonna just check with her and see. Now you're breaking into cars. I mean, I don't know what to tell you. You've been unemployed, and then you were working at Fast Splash Car Wash. You collected money on a bridge card. You need to go back and get a GED or a diploma. You need to work harder. I don't know why you're not working. You need to work. That's your decision, though. But to go out and support a family by eating all the time is not the answer.
Your Honor, he is working, and I updated the court on that.
I know you did, but still, this report was just done, right? This report was just, let me just double check this. I ordered the pre-sentence report on Mike for the past 8 months. Why were you unemployed for the 8 months preceding that report?
I wasn't unemployed, Your Honor. I was just helping my baby mother going through the postpartum and dealing with the kids. I was still working,
Well, you told them you were unemployed. Reports being unemployed for the past 8 months.
and I don't know why I put that, and I shouldn't have put that. I've been working since January of 2000.
All right. Lisa, you don't see any of those other warrants. I think you just answered my question. You don't see any other warrants cleared out of the locations I just mentioned, right?
I'm just running it right now. Give me 1 second.
Sure, take your time.
No, I don't see any other warrants.
You don't see what?
I don't see any other warrants.
Well, I'm just saying, see the lien in here, but probation reported open warrants issued to the 37th District Court, 16th, the 28th, the 34th, and the 52-3 District Court. Do you see any of those warrants on this lien now?
No, I just ran it and I do not see any warrants.
Good. All right, well, anything else?
Nothing, Your Honor.
He did not spend any time in jail on this, correct?
No.
Where's the child now?
She's going, Your Honor.
I'm sorry,
She's going, Your Honor.
was your the mother of the child here?
No, she wasn't here. Someone else came and picked her up.
You're supposed to mean like you become a professional thief. 200 fines, 400 costs, 75 victims' rights, $50 justice assessment, 7 1/4, and 40 days jail. You'll serve 325 more if you don't pay your fines and costs. I'll let you pay those at the rate of $75 per month. And I will let that start beginning on June the 15th. If you don't have the money at any point, you call the court. I'll be happy to give you an extension. You have 21 days to write it over. 212B7163361. Mr. Bryant, you need.
Here is Brian.
Listen. I'm not gonna put up with you yelling and screaming back there anymore. If I have to call you out here again, I'm gonna give you 30 days for contempt on top of the time that I just gave you. 30. You don't get to act like that. I hope you clearly and fully understand me. If you don't, I'm gonna have you out. Because I would hear you again. And then I'm gonna lock you up for 30 days. And we're gonna do this all day long. You're not gonna make a scene here in the courtroom. That sentencing, if anything, was too light. I'm not playing with you,
How is it too late?
Mr.
I have a judge that I gotta go to felony court. This is district court. I got sentencing on felony court.
Knock it off. Knock it off. And go tell them. You have 5 or 6 theft offenses, you're breaking into people's cars. You just think you could make a living by being a thief?
But I'm not a thief.
Oh, okay. Have a seat in the back, speak up again, you're getting 30 more days, I promise you, that's not a threat, it's a promise.
Bro, I don't give a fuck.
Good, come here, contempt of court, bring him up.
No, bro.
You're gonna send another.
You're gonna get I got people saying, you know, I don't care. You know, that the moon kill up. People stop for kill me. Be on run over flat. Stop understand all. At all. At all. So I got surgery on Monday now. You got fuck on my system. Oh my man. Stop. Fuck on me.
All right, settle down.
You off, man.
Go down.
No, you're gonna get taken, bro. Taste me, Jimmy. Taste me.
We don't want it. We don't.
Taste me. Stop resisting. Like I got kids that I gotta raise by myself. You ain't making it ain't dying. You keep making it seem like I'm just a thief. I gotta prove that I was see what you're doing. I gotta prove it first.
Knock it off.
Hey, listen to me.
Right.
Look at this. You're making it twice as bad.
Mr. Bryant, go back in the back. I'm gonna let bygones be bygones, except for the initial jail term. One more word and I'm telling you, you're doing 30 more days.
How many days?
Enough. Enough. Just control yourself.
Okay.
This courtroom hearing starts like so many others, quiet, procedural, almost predictable. A defendant stands before the judge, paperwork stacked neatly on the bench, the courtroom moving at its usual steady rhythm. But within minutes, the atmosphere begins to shift, and what unfolds becomes a tense, emotional, and at times chaotic exchange that leaves everyone watching with the same question: did he just make everything worse for himself? Triarius Travant Bryan appears in court facing charges for allegedly stealing a car. It's not a minor accusation. Auto theft is serious, and the judge already has the case file in front of her. But what immediately captures attention isn't just the charge, it's the fact that Bryan has brought his child into the courtroom with him. There's a noticeable pause as the judge takes in the situation. Courtrooms are not unfamiliar with emotional appeals, but this feels different. Whether intentional or not, the presence of a child in a sentencing hearing can send a message. It can signal hardship. It can signal responsibility. Or it can signal an attempt to influence the court emotionally. The judge addresses it almost immediately. Calm, controlled, but unmistakably firm, she states that she has seen this before. Bringing a child into court will not change the facts of the case. It will not alter the sentence. It will not create sympathy where the law requires accountability. She orders Bryan to arrange for someone to pick up the child so proceedings can continue properly. Right there, the tone is set. This is not going to be a hearing driven by emotion. It's going to be driven by facts. As the hearing continues, the judge begins reviewing Bryan's background. And that's when the weight of the situation really becomes clear. This isn't his first time standing in front of a judge. The court record shows prior convictions, retail fraud, motor vehicle offenses, and multiple outstanding warrants. Each line read aloud adds more context. This isn't a one-time lapse in judgment. This is a pattern. The courtroom grows heavier as the history unfolds. Prior chances, prior consequences, prior warnings. The unspoken question hangs in the air. How many opportunities does someone get before the court decides enough is enough? When the discussion shifts to Bryan's personal circumstances, he claims that he is employed. Employment can matter. It can show stability. It can suggest a path forward. But earlier information presented to the court indicated he had been unemployed for several months. The contradiction doesn't go unnoticed. Credibility in a courtroom is everything. Judges weigh not only the facts of the case but also the honesty of the person standing before them. When statements don't align, trust erodes quickly. And when trust erodes, leniency becomes harder to justify. Throughout the exchange, Brian's demeanor begins to show signs of frustration. Whether it's the reading of his record, the questioning of his employment status, or the realization that sympathy isn't working, the tension is visible. The judge remains composed, measured, and direct. She explains her reasoning carefully, outlining the seriousness of the charge and the significance of his prior record. Then comes the moment everyone has been waiting for, the sentence. 40 days in jail, along with fines and court costs. It's not the maximum possible punishment, but it's not a slap on the wrist either. It reflects both the current charge and the weight of his history. It's a consequence designed to send a message. And that's when things nearly spiral out of control. Instead of absorbing the sentence quietly, Brian reacts. An expletive slips out, whether under his breath or in open frustration, it's loud enough for the judge to hear. In a courtroom, even a single word can change everything. The judge responds instantly. Her tone sharpens, but she remains controlled. She informs him that if he continues speaking out or showing disrespect, she can add an additional 30 days for contempt of court. Just like that, the situation becomes even more serious. Contempt isn't about the original charge. It's about behavior in the courtroom. It's about maintaining order, authority, and respect for the judicial process. And in that moment, Brian is dangerously close to turning 40 days into 70. There's a pause that feels longer than it probably is. The tension is thick. One more outburst, one more comment, one more reaction, and the consequences could double. For a brief second, it looks like he might continue. Frustration is written across his face. But the warning lands. The reality of more jail time sinks in. Surprisingly, the judge decides not to impose the additional 30 days. She retracts the immediate contempt addition but makes it crystal clear that any further disruption will not be tolerated. It's a final chance. A line drawn clearly in the sand. The courtroom settles, but the energy remains heavy. What could have been a straightforward sentencing turned into a dramatic example of how quickly things can escalate. Looking at the entire exchange, several themes stand out. The attempt at sympathy through bringing a child. The weight of a criminal record that follows you into every courtroom. The importance of credibility when making statements about employment or personal progress. And perhaps most importantly, the impact of attitude. Judges are human, but they operate within the framework of the law. They consider history. They consider behavior. They consider honesty. And while they may show patience, that patience has limits. Brian's case becomes a powerful reminder that every action inside a courtroom matters. Every word, every reaction, every choice. The law doesn't just respond to the charge, it responds to the person standing before it. For viewer watching this unfold, it's hard not to feel the tension. You see the moments where things could have gone differently. You see the opportunities to remain calm, to speak carefully, to accept the outcome without escalation. And you see how quickly frustration can push someone closer to even harsher consequences. 40 days may not seem long in the grand scheme of life, but in that courtroom, it represented the culmination of past decisions and present behavior. It represented a judge weighing history against the possibility of change. And perhaps the most striking part of the entire hearing is how close it came to being worse. One extra sentence, one extra outburst, one extra moment of defiance, and the outcome could have doubled. In the end, the courtroom stands as a place where strategy, emotion, and reality collide. Attempts to manipulate rarely succeed. Contradictions weaken credibility. And disrespect can cost more than anyone expects. This hearing serves as a vivid example of how the justice system responds not only to crimes, but to conduct. It shows that while the law can be firm, it can also offer restraint, but only up to a point. For anyone watching, the lesson is clear: when you stand before a judge, the smartest move is composure. Because in that room, consequences are decided in real time, and sometimes, the difference between a bad outcome and a worse one is just a single word.